We all walk around with tracking devices on, cell phones. While these devices report our location on an almost minute-by-minute basis, have you considered the rules law enforcement must have to follow in order to search that data? Talk about that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach, write, and generate free. Glad you could join me today. This idea of geofence warrants has been a big deal lately, and along with automatic license plate readers, well, it's been at the forefront of Fourth Amendment questions. Now, the recent case we'll cover here at the Supreme Court deals with whether or not a geofence warrant constitutes a search under the Fourth Amendment. Now, if you want to follow along, you want to follow my quotes, well, head to the website, constitutionstudy.com. You can find this article and see the links to all of my sources and double check the work that I'm doing here. Now, I'll talk more about the website and what you can do up there at the end of the episode. But for now, let's take a look at this case involving geofence warrants. There are times when people who have done bad things need their rights protected. That appears to be the case here. The story starts with a 2019 bank robbery. On May 20th, 2019, a man robbed a credit union in Midlothian, Virginia. Local police officers learned from witness interviews and surveillance footage that the robber had approached the credit union from a corner of an adjacent church while appearing to talk on a cell phone, but they could not find out anything more, and the robber remained at large. Like so many investigations, this one started with witness statements and surveillance footage. Both stated that the robber approached the credit union while talking on a cell phone. June 14th, the police officers applied to a Virginia magistrate for a geofence warrant directed to Google, which would require Google to hand over data about cell phones located within a 150-meter radius of the credit union, the so-called geofence, near the time of the crime. The application described the cell phone location data Google collects through a service called Location History, which records the location of a user's cell phone every 2 minutes or so. Did you know that you're walking around with a tracking device on? Every cell phone contacts a local tower to let the network know how to route calls to it. In the case of Google devices, they collect that data through their location history services. This is the database of information law enforcement was asking permission to search through a geofence warrant. The application also explained how the cell phone location data could help identify the robber, possible accomplices, or additional witnesses. Now remember, the warrant clause of the Fourth Amendment states, "No warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Geofence warrants are a bit unique, as the opinion describes. The warrant describes a three-step process that the police would follow. At step 1, Google would produce anonymized location data for all cell phones within the geofence 30 minutes before to 30 minutes after the robbery. The first step in this geofence process is a list of cell phones within the designated geofence area and a period of time. This data is anonymous, meaning the police know which cell phones were in the area, but not who owns them. Now, at this point, the only information being provided is the location and phone identifier. At step 2, officers would attempt to narrow the list, and Google would provide additional anonymized data for that narrowed list, consisting of cell phone locations both inside and outside the geofence during a 2-hour period surrounding the robbery. Now, step 2, law enforcement narrows the list to devices they are interested in. Google then provides data over a greater period of time and no longer bound by the geofence. And at step 3, officers would further narrow the list, and Google would turn over identifying information, including names and phone numbers for users on the final list. Now, at step 3, law enforcement further narrows the list of phones of interest, and Google turns over personal information about the owner, including their name and phone number. The magistrate issued the warrant, and through this process, Google ultimately produced 3 cell phone users' identifying information, including petitioner Okello Chaudhry, whose location data showed that he entered the geofence about 10 minutes before the robbery and headed toward a residential area immediately after leaving the bank. The magistrate issued the warrant, and the 3-step process led to the identification of 3 cell phones, including Mr. Chaudhry's. Now, further investigation led to a grand jury indictment of Mr. Chaudhry. However, Mr. Chaudhry challenged the data collected through the Geofence Warrant. According to Chaudhry, the officers had acquired that data through a Fourth Amendment search, and the warrant ostensibly authorizing the search was invalid. The district court found that the Geofence Warrant plainly violates the rights enshrined in the Fourth Amendment, but denied the motion based on the good faith exception to the exclusionary rule. A divided panel of the Fourth Circuit affirmed on different reasoning, holding that no search occurred because Chaudhry did not have a reasonable expectation of privacy in 2 hours worth of location history data voluntarily exposed to Google. The Fourth Circuit granted rehearing en banc and affirmed in a one-sentence per curiam, with the court dividing evenly on whether a Fourth Amendment search had occurred. This court granted certiorari solely on the question whether the police violated the Fourth Amendment in obtaining Chaudhry's location data. 2 federal courts, for 2 different reasons, denied Mr. Chaudhry's motion. Do these reasons hold water? Now, since the question before the court was whether or not the police conducted a search under the Fourth Amendment, Justice Kagan, who wrote the majority opinion, details the issue. The Fourth Amendment protects individuals' reasonable expectation of privacy, and governmental intrusion into the private spheres generally qualifies as a search. That's from Carpenter v. United States. The amendment's basic purpose is to safeguard the privacy and security of individuals against arbitrary invasion by government officials, and it was designed to place obstacles in the way of permeating police surveillance. That's from the United States versus DeRay. The Fourth Amendment doesn't say anything about privacy, but more on that later. It is designed to safeguard our security from arbitrary invasion by government officials. Did you notice that Justice Kagan uses precedent rather than the actual language to support her position on what the Fourth Amendment says and does? In Carpenter, this court held that accessing cell site location data constitutes a Fourth Amendment search because individuals have a reasonable expectation of privacy in the whole of their physical movements. Now, the court held in Carpenter that accessing cell site location information is a search under the Fourth Amendment. This makes sense because cell phones didn't exist when the Fourth Amendment was ratified. This is the type of controversy the federal judiciary was designed to resolve. But since the Fourth Amendment makes no mention of privacy, how did the Carpenter court come to this decision? The court reasoned that CSLI provides a detailed and encyclopedic portrait of persons' whereabouts, and with that, an intimate view into a person's life. Because people compulsively carry their cell phones all the time, the court explained, a cell phone tracks nearly exactly the movement of its owner and thus faithfully follows him not only through public thoroughfares, but into private residences, doctor's office, political headquarters, and other potentially revealing locales. An interesting, if somewhat convoluted way for the court to come to its conclusion. How about the fact that once I purchase a cell phone, it becomes one of my effects? Or the fact that I contract with another entity, in Mr. Chaudhry's case, Google, does not change the fact that the cell phone is part of his effects, which the Fourth Amendment requires to be secure from unreasonable searches. The court further observed that the newly found tracking capability that CSLI gives the police runs against everyone, not just those under investigation, and travels back in time, making possible a form of surveillance that would have been unknown prior to the digital age. Carpenter accordingly held that allowing government access to cell site records contravenes expectations of privacy. I would say that unwarranted searching of data related to me, my phone, and my interactions with the service provider constitutes my effects and therefore are to be kept secure from unreasonable searches. The government's argument that accessing only a short amount of cell phone location information does not count as a Fourth Amendment search fails. Even short-term monitoring can provide a wealth of detail about a person's familial, political, professional, religious, and sexual associations. And this court has never understood the Fourth Amendment protections as kicking in only once an intrusion goes too far. That's from Pennsylvania Coal Company versus Mahone. Where the Fourth Amendment applies, it applies regardless of the quality or quantity of information the government obtains. That's from Kegel v. United States. That approach makes all the more sense when, as with location history, law enforcement officials can select the time-limited set of materials they want from an all-encompassing database. The government's argument that they only collected a little bit of data makes as much sense as claiming someone's only a little bit pregnant. The government argues that the so-called third-party doctrine precludes Chaudhry from invoking the Fourth Amendment's protections. The idea is that in authorizing Google to collect, retain, and use his location information, Chaudhry lost his legitimate expectations of privacy and therefore his right to complain of a search. The old third-party doctrine. This laughable idea of previous court came up with that when you give your papers or effects to a third party, it loses all Fourth Amendment protections. Of course, this has nothing to do with the Constitution, only the court's twisted logic to promote the violation of your rights. But not all the time. But Carpenter refused to apply the third-party doctrine to CSLI, and no good reason exists to reach a different result for location history. In Carpenter, the court rejected application of a third-party doctrine to CSLI because such information is qualitatively different from telephone numbers and bank records. It is incomparably revealing and is not truly shared, as one normally understands the term, given that cell phones are indispensable to participation in modern society. So it's not that the third-party doctrine is a wholly made-up thing, just that the court thinks it doesn't matter here because cell phones are indispensable to participation in modern society. I hate to tell you this, Justice Kagan, but so are telephone numbers and bank records. The conclusion that a Fourth Amendment search occurs does not resolve the case, because the Fourth Amendment prohibits only searches that are unreasonable. Now, when law enforcement officials undertake a search to discover evidence of a crime, the reasonableness standards generally requires that they seek a warrant from a neutral and detached magistrate, who may issue a warrant only when probable cause is properly established and the scope of the authorized search is set out with particularity. The warrant issued here, as described earlier, was an uncommon multi-step one, and the parties have contested the legality of each stage of the search process it authorized. The Fourth Circuit did not address the questions that unusual warrant raises. Because this is a court of review, not of first review, the court leaves it up to the Court of Appeals to decide whether, at each step of the search process, the warrant satisfied the Fourth Amendment's requirements of particularity and probable cause. So SCOTUS agrees that Chaudhry's data was searched under the Fourth Amendment, but leaves it up to the Court of Appeals to determine if the warrant was valid. Now, Justice Jackson concurred with the majority, but not entirely. I agree with the court that law enforcement officers conducted a search when they accessed Petitioner Chaudhry's location history. I write separately because I would have gone further to explain that this search violated the Fourth Amendment. As the court observes, when officers have obtained a warrant, the validity of the search turns on whether a magistrate has properly found probable cause to support a particularly described search. In my view, it is clear that at a minimum, the second and third stages of the search process here did not satisfy this foundational requirement. Interesting. Justice Jackson was okay with the original request for the geofence, but not the subsequent request for data. I wonder why. At Step 2, the warrant authorized officers to access an additional hour's worth of location history unbound by the geofence's perimeter. Though the warrant stated that officers would attempt to narrow the list down of devices subject to the step, there was no explicit requirement that they do so. Nor did the warrant set forth any criteria that officers would use in their narrowing efforts. It appears Justice Jackson has a concern with the specificity of the warrant at the second and third steps. After all, the Fourth Amendment's warrant clause requires a warrant to particularly describe the place to be searched and the persons or things to be seized. The problems become worse at the third step, since now Google is expected to turn over not just devices that were in the area, but the personal information of the owners. The same infirmities carry over to Step 3. At this step, the warrant authorized officers to access identifying account information, including the username, date of birth, account number, and any email addresses or telephone numbers associated with the accounts. Once again, the warrant stated only that the officers would attempt to narrow the list without setting forth any criteria to do so. Now, since neither Step 2 or 3 actually required law enforcement to narrow down the list of devices whose owners' data it would be shared, it no longer particularly described devices to be searched, and the data for whose devices is to be seized. Now, Justice Gorsuch agreed with the majority, but for a different reason. I agree with the court's judgment that the government examination of Okello Chaudhry's location history data amounted to a search for purposes of the Fourth Amendment. But respectively, I would reach that conclusion by a different route. It appears Justice Gorsuch's route is based on the definition of what a search is under the Fourth Amendment. To decide whether a Fourth Amendment search took place in this case, the court once again invokes a test first advanced in a solo concurrence in Katz v. United States. Under that test, a search occurs when the government intrudes on an expectation of privacy that society is prepared to recognize as reasonable. Surprise! The Supreme Court based its decision not on the Constitution or laws of the United States, but their own previous opinions. That precedent seems to be Justice Gorsuch's problem. The Fourth Amendment's protection do not depend on the breach of some abstract expectation of privacy whose contours are left to the judicial imagination. Instead, the Fourth Amendment speaks in more concrete terms, protecting an individual's person, houses, papers, and effects from unreasonable searches and seizures. No surprise, then, that it's hard to find anything like the cat's test in the law leading up to the Fourth Amendment's adoption, or anything much like it in the court's jurisprudence before 1960s. I'm glad to see that at least Justice Gorsuch sees that the term privacy does not exist in the Fourth Amendment. Rather, it's a question of when is a search reasonable. Now, rather than employ CATS and its third-party doctrine, I would take a different approach. To decide whether the Fourth Amendment is at play, I would consult its terms and ask first whether location history qualifies as one of Mr. Chatry's papers or effects, and then asking whether the government searched those papers or effects. The traditional approach remains very much part of our law. Indeed, we have expressly recognized that CATS and its progeny supplement rather than displace traditional Fourth Amendment principles. It's nice to see not just one, but two justices looking at a case based on the language of the Constitution, not just the opinion of their predecessors. Now, sadly, when it comes to justices looking at the law rather than precedent, Justice Alito failed in this case. 8 years ago, I warned that this court's decision in Carpenter v. United States would produce one of two outcomes. Either the court would need to clarify Carpenter's limits in a future decision, or Carpenter would usher in revolutionary developments in our doctrine by giving criminal suspects a protected Fourth Amendment interest in any sensitive personal information about them that is collected and owned by third parties. Today, the court takes the country down the latter path. In doing so, the court sheds Carpenter's self-imposed boundaries and further destabilizes long-standing Fourth Amendment jurisprudence. Justice Alito reminds the court that he warned them of the consequences of the Carpenter decision, then chastises them for not following it. Just because the court has opined some Fourth Amendment jurisprudence doesn't mean that that jurisprudence is correct. Justice Alito further shows his slavish devotion to precedent later in the dissent. Although today's decision will send seismic waves through our Fourth Amendment doctrine, not one iota of the majority opinion will affect the outcome of this case. The court knows this and does not claim otherwise. Indeed, by refusing to review the one question that could have at least theoretically given Chatry some hope of relief, the court carefully set the stage for its planned performance, striking a pose as a great champion of privacy in the digital age. I cannot support this irresponsible escapade. I guess Justice Alito forgot the question before the court in this case. You see, SCOTUS was not asked to provide Mr. Chatry relief. The questions presented are whether the execution of the Geofence Warrant violated the Fourth Amendment, and whether the exclusionary rule should apply to the evidence derived from the Geofence Warrant. Whether disqualifying the evidence collected by the Geofence Warrant changes the outcome of the case is not the point. Deciding the controversies around Geofence Warrants is. And in that aspect, Justice Alito failed. Now, Justice Barrett had the shortest dissent I think I've ever seen. That's not to say there isn't a point worth looking at. I have no quarrel with Carpenter v. United States, or with the court's decision to grant certiorari in this case. But I agree with Justice Alito that under the Fourth Amendment precedent, including Carpenter, Chatry had no reasonable expectation of privacy in data about his public movements that he voluntarily disclosed to Google, and therefore respectfully dissent. Again, Justice Barrett, the Fourth Amendment doesn't claim to protect someone's expectation of privacy. No one I know is arguing that Google didn't have the legal right to collect data about Mr. Chatry's location, or to keep it for historical purposes. Rather, the Fourth Amendment protects people from searches and seizures that are unreasonable. Does a warrant with a varying scope of search meet the requirement for particularly describing the place to be searched and the persons or things to be seized? What about the fact that, while there may be probable cause for the anonymous search, what is the probable cause for the detailed owner information? Now that we've looked at the different positions that justices the court had on this case, let's look at the court's conclusion. Held. Police officers conducted a Fourth Amendment search when they acquired Chatry's location data from Google because an individual has a reasonable expectation of privacy in his cell phone location information. Yes, a geofence warrant involves a search under the Fourth Amendment. However, the court keeps falling back on this expectation of privacy. Now, I agree an expectation of privacy is involved when the data is collected, but the Fourth Amendment doesn't protect a person's expectation of privacy. I would agree that most people would expect that any data they share with a service provider, especially one they've contracted with, is private. But what you expect to be private is likely to be different from what other people expect to be private. The problem here is the question of search and seizure. Did the police have probable cause, supported by oath or affirmation, to get a geofence warrant? At step one, it appears to be yes. They had both video and witness testimony that showed the alleged criminal on a cell phone. Therefore, they had probable cause that collecting anonymized data about the devices in the area at the same time was a reasonable search. However, when the time frame was expanded beyond the half hour before and after the crime was committed, what was law enforcement's probable cause for that? They didn't provide one. When specific devices were targeted and owner information was seized from Google, what was law enforcement's probable cause? Again, they didn't provide one. Before you get all upset about the unconstitutional acts of law enforcement, don't forget a magistrate issued this warrant. That magistrate is just as guilty of depriving Mr. Chatterjee of his rights as the officers were. To me, this is the fatal flaw in the district court's opinion. The district court found that the geofence warrant plainly violates the rights enshrined in the Fourth Amendment, but denied the motion because of the good faith exception to the exclusionary rule. The idea that a judicial magistrate can violate someone's rights by issuing an invalid warrant, but it's okay because law enforcement actually executed the warrant in a good faith, is roughly equivalent to, well, war crimes being dismissed because, well, people were only following orders. While the officers may not be culpable, that doesn't relieve the grievance of violation of rights based on the good faith doctrine. Now, will this decision overturn Mr. Chatterjee's conviction? Not necessarily. For the reasons stated, we vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Now, hopefully, the Circuit Court will recognize the unconstitutionality of this geofence search and send the case back to the District Court. Maybe then the District Court will fulfill its oath of office to support the Constitution of the United States rather than the good faith of the officers. Overall, a win for the Fourth Amendment to the Constitution of the United States. Yes, geofence warrants have the same requirement as a search under the warrant requirement. And therefore, it has to have a warrant that meets those requirements. Probable cause, oath or affirmation, particularity. Now, probable cause at stage one? Absolutely. I don't see a problem with that. But when did the officers narrow the search? Does that change the probable cause? Why do I need more time data? Why do I need data for more time before and after of this subset? Never happened. When they got personal information, well, what's your probable cause to expose the personal information? Again, they never provided that. Now, some of these arguments from the justices are pretty much the foolishness I've come to expect. Slavish devotion to precedent rather than the law and the Constitution, and this obsession with privacy when that's not mentioned in the Fourth Amendment. But let's take the win. This is a good news. This is a good standing. And, well, we'll just have to see how future courts deal with this situation. Now, if you want to find out more, again, head to the website, constitutionstudy.com. Follow all my links. You can read the entire opinion, all the dissents, all the concurrences. You can also sign up for a mailing list. Maybe get emailed when I release these articles and videos. Or maybe you can just want to follow along with the news or other things that I'm working on. Of course, I'd also love it if you went and stopped by the shop and picked up something. Go to constitutionstudy.com/shop, and you can pick up a book, a t-shirt, a mug, all of which, by the way, goes to keeping the Constitution Study up and running. Nobody here takes a salary. Don't take any money out. We put money in to keep this going, and if you can help, that'd be great. In fact, if you just like to donate to the cause, there's a donate page there as well. You can make a one-time or recurring donation, and remember, every dollar goes to keeping the Constitution Study up and running. Of course, you can also support us with, of all things, your cell phone. Talking about geofence warrants and cell phones, Patriot Mobile is America's only Christian conservative wireless provider. Not only do they have great service and great plans, they take a portion of every dollar to support organizations like the Constitution Study that are fighting for your rights. Freedom of religion, speech, press, to be secure from unreasonable searches and seizures, even to protect your due process rights. So if you go to patriotmobile.com/constitution, you can find a plan, and when you pay your bill, you're supporting organizations like the Constitution Study. By the way, see if you're eligible for a discount. Families with multiple lines, veterans, first responders, and many more can get discounts to make it even better. Oh, by the way, use the code Constitution at checkout, and you'll get free activation as well. So get great cell phone service and, well, save yourself some money and do some good with it by going to patriotmobile.com/constitution, finding a plan and discount that works for you. Don't forget that code Constitution to get free activation and support the Constitution Study and other great organizations with your cell phone. Now, I hope you like what we did here. I hope you found this episode interesting. I hope it was interesting enough that you'll be interested in coming back. Maybe bring a friend or two the next time we meet for the Constitution study.